First of all, it's great to be joined by so many people today. I understand that over 125 people have signed up, and my key message is, at the moment, hope you're all safe and well. I'm delighted to be chairing this virtual conference about virtual DR for Thought Leaders HNW divorce community. It's been fantastic to pull this off to get together in such record time, and thanks to all the speakers for making yourselves available, although frankly, where else can you be? Thank you very much. Today, we're going to be exploring all forms of dispute resolution: early neutral evaluation, mediation, hybrid mediation, collab, arbitration, with particular reference to the new children rules which actually came out today, and we've got an amazing panel dealing with private FDRs. We will be sharing our top tips for virtual dispute resolution in COVID-19, what to do, what not to do. We are very happy for questions to be submitted, and if you're going to do that in the audience, can you please submit them via the question and answer function in Zoom? That's the way to get the questions to us. So without further ado, I'd like to start by introducing our first panellist, Karen Walker. I've known Karen for many years. She started her firm, KGW Family Law, in 2012. She's a fabulous mediator, trainer, and does all forms of family law work. Karen, before you start, I just wondered, is there a new skill or something you've learned about yourself since we've been going through this crisis?
Well, my IT skills, Suzanne, have gone through the roof in 2 weeks. So I can now type things I never knew would be possible. I can attach documents to all sorts of things. And having been reliant on a fabulous PA for the last 8 years, who's taken all of that away from me, I've suddenly had to really come up to the plate in a very short space of time. But actually, it's been fine. And I've also had plenty of time to deal with my vegetable garden. So that's been a real...
And now you're going to talk to us about hybrid mediation. So the floor is yours, Karen.
I am, thank you. It's very strange to be talking to people I can't see. So that's also a first. So I thank you very much, as Suzanne said, for logging in. And I hope that you find this informative. So hybrid mediation, in a sense, is as described. It's a hybrid version between the family model and the civil model. And Henry Brown, whom most of you involved with mediation would know, brought together a training program to deal with this, which he kindly asked Suzanne Kingston and myself to participate in, initially about 18 months ago. Now, the model, I think, really rises to the fore in the current situation. In effect, it's exactly the same as family mediation, save with two major differences. It becomes common to involve both parties' solicitors within the process, which means that the couple have that added layer of comfort and support while working through it. And also the process enables the mediator to hold confidences, not there's an offshore bank account with 3 million stashed in it and please don't tell the other side, but if there is something which might aid the process, then the mediator can keep that to themselves until the time is right for it to be introduced into the negotiation. At the present time, the court system is in a complete disarray. I think we knew that anyway, but nothing like an inability to hold functioning court hearings is going to make it struggle still further. I'm a firm believer that separating couples either want to be helped to reach their own agreement or have somebody make an adjudication. Many people will tell you that mediation is only suitable for a particular number of individuals who are able to negotiate, feel comfortable sitting with their partner or spouse, have a modicum of agreement working between them already, and therefore feel comfortable in that forum. A great many people, of course, don't fall into that category. Now, hybrid mediation provides a safe environment supported by lawyers where you don't have to be in the same room and where you can endeavour to carve out your own agreement without something being imposed on you in a very safe and controlled environment. Suzanne asked me what I had learned to do since COVID-19 came into being. Well, since the 24th of March, I've done a hybrid mediation at least every other day, because the rise in requirement has been enormous. So many people who've had court hearings which are now not going ahead, or not going ahead as they expected, who don't feel that they can mediate in a usual roundtable environment, but see this hybrid method as a real means of involving their solicitor, negotiating in a safe place, doing it on Zoom or via some other platform, and moving their lives forward in a situation which is currently extremely difficult. And it does enable the solicitors to be very involved with the negotiation, to support their clients, to work with the mediator, and to bring about an outcome which works. In the next session, you're going to hear about a method of working called the Certainty Project, and without wishing to encroach on that, when they talk to you about mediation, do please think about the hybrid mediation model as a very effective model to use within that, because all of the nervousness about mediation is taken away. The nervousness of having to confront your spouse or partner, the nervousness of being in a negotiation without the support of your lawyer, and the concern that you would just feel out of your depth and in a difficulty. So this very supported and altered model works extremely well. Now, Suzanne and I have run a training course without the assistance of Henry on one occasion. We did have something set up with resolution to take place in May. What we're looking to do is bring that forwards and make it online. And as I say, I think it's a really valuable skill to have if you are a mediator moving forwards, because of its flexibility and the way that it works so well. I would wholeheartedly endorse it as a way to work with separating couples who perhaps couldn't mediate in the traditional form, but do feel that this provides that safe environment. I'll give you very quickly an example of holding confidences. So I've done a mediation via this route earlier today. And one of the important points is the husband is going to be made redundant, and the wife is prepared to leave the redundancy package out of the deal if everything else works, but she doesn't want me to tell him that at this stage. And I think it's a really good demonstration of how I can hold that as a negotiating tool and use it within the process to hopefully get them to a deal. The other benefit is it can be very quick, as you can arrange meetings in rapid succession. And if you can't reach agreement, you've got some way, but not all of the way, then there are other processes to square the circle, which others will talk to you about today. So Suzanne, I hope that gives the overview that was required for the purposes of today's seminar.
Yeah, I'm sure there'll be some questions, but we'll leave those to the end, Karen, because we're just racing through the speakers at this time. Thanks very much. And we're now moving on to hear more about the Certainty Project, which is going to be presented by Nadia, Beckett and Julian Bremner. Nadia has been a solicitor specialising in family law for over 25 years and a mediator since 1997. She established Beckett Solicitors in August 2008. She is a family law arbitrator qualified in both children and financial schemes, and she's the chair of the FFA. I think that was originally going to be called FAF, but the Forum for Family Arbitrators, and is a member of the IFLA Advisory Committee. I heard from her that in her time in social distancing, she's been learning to host dinner parties via Zoom. Great skill to have, probably for a few months, if I may say. Julian is a partner at Raven Solicitors and also a qualified financial arbitrator. He has a particularly strong line in complex and international cases, specialised in medium to high value matrimonial cases. He also regularly deals with civil partnership disputes, cohabitation disputes, separation agreements, prenuptial agreements and additional financial provision for children of unmarried parents. Now, in his time, he's taken up online yoga because, well, there's nothing else to do and he's bored enough to try it. So if I could ask Nadia and Julian to talk to us about the Certainty Project, that'd be great.
Thank you, Suzanne, and hello everyone. As Karen said, it's slightly weird talking to people I can't see, but I'm sure we'll manage the process. So Julian and I are going to do this as a kind of an interview. We thought that would be a style that would give you a bit of variety. I'm just going to introduce the Certainty Project by explaining that this is something that was created by Julian, Karen Walker, who you've just seen, and also Margaret Kelly. And it was a very ingenious idea devised, I think, late last year or over a period of time. And I'm going to ask Julian to start by telling us a little bit about the Certainty Project. Julian.
I hope I'm on and that's working. So the Certainty Project, what we were thinking about was we wanted something that used existing ADR processes, but put them together within a structure that enabled everyone to work coherently to a plan. The key to this project is client service. It's about giving your client the certainty of a beginning, a middle, of an end, and allowing them to take control of the process as much as possible outside of the court forum. I'm going to talk to you briefly about how it works for the financial program, and there's a whole raft of material which I think should be emailed to you, if not now, at the end of today. But effectively, the Certainty Project starts with two parties agreeing to engage in the project with their solicitors. The first step to take, as this is an arbitration-led process, is to engage an arbitrator, fill out your documentation, and start that off. The arbitrator then sets out effectively the sort of things we'd see in Form C, so completion of Form E. And if it's apparent, even at that early stage, experts are needed, direct for experts, etc. At that point, the solicitors take over and prepare Form E as they would for court. So the solicitor's role is doing what solicitors do very well indeed, and that is try and get the disclosure into apple pie order. At the end of that process, the solicitors try and agree an asset schedule, or at least highlight on an asset schedule where they aren't agreed. One of the golden rules of the project is, although the solicitors, of course, advise their client, that's what solicitors do, we are not sending without prejudice offers. The parties then move to the mediation phase with their selected Certainty Project mediator. The mediator has the asset schedule and whatever other documentation that mediator needs to move forward. Parties engage in mediation. The mediator is a little more controlling perhaps than normal. The mediator is looking out for if one party is deliberately trying to stall or not, and may end mediation earlier. This is one of the key selling points of the Certainty Project. So in an ordinary mediation, if the parties agreed, let's say 6 out of the 10 points they had to, and they couldn't get the final 4, they may need to start the process all over again. Whereas with the Certainty Project, achieving some of the answer, if not all of the answer, is an absolute win. Mediator reports back to solicitors. If the parties have come to an agreement, the solicitors prepare an open summary for the arbitrator to review and make an award. If they don't, the solicitors set out on an open basis what is now agreed and what is not. So the arbitrator rescopes that arbitration and the arbitration takes place as normal.
Thank you, Julian. And who is the Certainty Project aimed at? Who are the clients? And is the Certainty Project suitable for everyone?
I think the Certainty Project is suitable for the vast majority of cases we undertake. It is aimed at people who can, well, frankly, afford to go private, but also want to control the process themselves. It's aimed at people who want the opportunity to try and resolve their own problems, but also have an end game in sight if they are unable to do so.
But what about litigants in person? Is it suitable for them?
It's not suitable for two litigants in person. It is suitable if one party is represented and is prepared to help the litigant in person through the parts of the process they need to do. One of the key points of this is that it's professionals working together in a very mature and adult manner. So almost like the collaborative ethos of working together in partnership to try and resolve matters for parties. So if you are able to work like that with a lit, then go for it.
Okay, but as the case is going on to mediation, I mean, of course, the mediator has a role in determining whether a case is suitable for mediation. That's normally the purpose of the MIA or the intake meeting. So if a couple sign up to the Certainty Project, how does it work if the mediator then decides that the case isn't suitable for mediation?
Well, I would have thought that at the very first vetting stage, when you're talking about process options and that first meeting to your client, you are considering at that juncture whether mediation may not be suitable because of domestic violence. We've heard, of course, from Karen that, of course, there's such a wide range of mediation that more or less every case, I think Karen would tell us, is suitable for mediation. So I think you're working on that basis. You're working on the basis that these are parties that could do some form of mediation.
Great. And I suppose because this is being taken out of the court arena, if the mediation breaks down, then the parties won't need to obtain any type, they won't need a certificate, will they? Which potentially gives the parties more choice of mediator, because the mediator wouldn't necessarily have to be accredited.
Yes, that's right. I mean, the parties are selecting their solicitors, mediators and arbitrators right from the very beginning. So they know they're working with professionals who are trying to help them resolve their problem. It's arbitration, so you don't need a MIAM. So yes, it does give you a range of choice. And this is what it's all about for the clients. This is the customer service element, choice.
And disclosure is obviously a really important part of the process. So why do the disclosure with solicitors rather than doing it through mediation with the mediator?
Two reasons. Firstly, solicitors are very good at preparing for me and disclosure and making sure that all I's are dotted and T's crossed, making sure that perhaps if you need an expert to report, that's also undertaken. You know, so it's doing what solicitors do best. It also means that parties can hit mediation with the relevant information already there. They're not wasting time trying to, you know, get the disclosure into a point where the mediation can really go forward. Also, it's part of the business case because this project has a business case to it as well. This is what the solicitors do really well, so let's get on and do it, because we all know that until you have a proper asset schedule, you can't settle anyway.
And I mean, I'm sure that some of our audience might be thinking, well, why use the Certainty Project? I mean, why not just go forward with the mediation? If the mediation breaks down, then you can sign up to arbitration. Why sign up to arbitration before the mediation? What are the benefits of that?
Well, again, it's customer service. It's allowing the clients right at the beginning to opt out of the court process and choose a process that gives them the opportunity to resolve matters themselves, or if they can't, move swiftly into a decision. It also means that this process is going to be as swift as it needs to be for the particular parties. So the idea is you're reusing the same disclosure. There's not this bit where you have to wait 6 months between first appointment to FDR. You have to redo your Form E, you have to redo this, that, and the other. Things drift, things change. The idea is to help parties through. Okay,
and I think we've got perhaps 1 minute left, Julian.
Really you've got a bit longer if you'd like it, Nadia. If you need more time, you can have a bit more.
Thank you very much, Suzanne. Maybe 2 minutes then, Julian. I think it would be helpful to really, I suppose, what's in it for the clients?
I think for the client, it is that choice. We've all had that situation where clients have been negotiating, maybe in and out of mediation, maybe through solicitor-supported direct negotiations. It's come to a bit of an impasse. They need a third party to help them. And, you know, the client begins telling you, well, you know, I want it by this time, so little Johnny needs to go to this school. I need to organise this. I need to organise that. and the slight look of horror on their face when you say, when you commence proceedings, first appointment may be here-ish, if it actually goes ahead, FDR might be here-ish, and it's giving them control, because you can now fix this dispute resolution around their own life events and their own things that are important to them.
Thank you. Thank you, Suzanne.
Brilliant. Indeed, I think that's a crucial point at the moment, isn't it? There's so much difficulty with the courts, and the timing of things could just go off into the long grass. So looking at these cutting edge propositions is absolutely crucial. So thanks very much to Nadia and Julian. And we've got another duo coming up, and these are the award-winning duo. Every time I see anything on Twitter or anything like that, it seems to mention Samantha Woodham and Harry Gates, both barristers at 4 Paper Buildings and co-founders of the divorce surgery. They're here to talk to us about the divorce surgery, but I'm quite interested in your new skills. So starting off with you, Harry, what's your skill that you've learned during this time?
Well, I'm halfway through learning how to use a chainsaw,
oh, wow.
which is dealing with my feelings of frustration at being cooped up inside.
Okay, and what about you, Sam?
Yeah, so 2 things. I've started doing cosmic yoga with my kids, which has been quite fun. And the other thing I've been trying to work out is how to make a quarantini.
Oh, yes.
Yeah, there's a lot of chat about it, but there's no recipes. But I've been trying to devise.
I had lots of cards. It's my birthday the other day, and I had loads of cards containing quarantine recipes, so I can send one to you.
Yeah,
right,
do.
It's your turn.
Right, well, I'm going to start off. Thank you, Suzanne, for that introduction. This very short talk is just going to recap a little for those who know and tell those who don't know what one couple, one lawyer is, which is the process that the divorce surgery operates. And then explain a little bit about how that differs from private FDRs. And then finally, what cases one couple, one lawyer is really suitable for and those that it isn't. So without further ado, what is one couple, one lawyer? In a sense, it's the Ronseal of legal processes. It really sort of, I can't really improve on those 4 words, one couple, one lawyer. In a nutshell, couples have the ability to have very early legal advice, and I do emphasize the very, with one impartial barrister that they choose together, who will never represent either of them going forward in the case, if indeed there is to be a case, once the advice has been given. Well, why do we do that? Well, I'm sure all the delegates to this seminar will need no persuading that all the statistics show that early settlement is vital for outcomes for children and for families generally. And in a sense, what we try to do with this process is to harmonise people's expectations right from the beginning. If they're sitting at the very earliest stage in a room, listening to advice from somebody who is an expert in their field, and I'm not talking about me particularly, and Sam will come on to explain about that in due course, and hearing the advice that they're both getting from that one barrister, then it really does have a difference. It's a very powerful process, actually, once you've seen it in action. So that's the plan. We're regulated by the BSB and fully insured by the BMIF. It was a fairly tortuous process becoming regulated. I appreciate it. It was a novelty for the BSB to be dealing with, and they certainly did very well with us, but it's quite a long process. In terms of what we ask of our clients, our process typically lasts 6 to 8 weeks, and it's for a fixed fee. It starts at £4,750 plus VAT. It slightly depends thereafter on the complexity of the case as to what the costs will be. But all the costs are fully quoted for before anyone commits to the process. Couples are screened individually at the beginning at what we call an introductory session for us to be able to ascertain whether there are any red flags as to why this wouldn't be suitable. For example, a looming jurisdiction fight, obviously a joint process isn't going to work for them, or serious allegations of relevant domestic violence and those sorts of things. But assuming that they pass that threshold, and indeed we pass their expectations, there then follows a disclosure process which we organise for them. And essentially we ask for all the information that is absolutely vital and none of the information that we don't consider vital. So for example, unless there are specific issues about the contents of bank statements, there does not follow backwards and forwards pages and pages and pages of bank statements in the process. In more complicated cases, we have a bespoke disclosure session, which is a session which both parties join with the barrister who's going to be advising them in due course, and any questions, queries can be ironed out with the barrister and further plans made to provide documents which are missing. And once all the disclosure is in and has been exchanged with each other, it's time for the advice. And the advice session usually lasts 2 or 3 hours, takes place exclusively remotely at present. And the barrister will essentially give a bracket as to what he or she thinks a court would do in the circumstances of their case based on the disclosure that has been exchanged. It is not a negotiation. It is essentially akin to an FDR indication. It's a very detailed one. And it's then followed up in writing. I don't think we quite commit to this, but about 2 days later. And that tends to be a 15, 20-page detailed written advice given on a privileged basis, which sets out all the advice that's been given. And that is essentially the end of our process. As I say, we don't negotiate. It's not a backwards and forwards in that respect. Of course, if people want to ask questions or don't understand part of the advice, then clarificatory questions can be asked, and again, responses provided on a privileged basis. But we do not try to finalise the case with them, as it were. Instead, we try to urge our customers to regard this as a tool, one of the many tools that they should be using in order to try to settle their case. And what we've found is that people like to take this advice particularly into mediation, certainly round table meetings, or indeed negotiate directly around the kitchen table. A final option, which is certainly available to them, although we hope not too many people do this, is to rip our advice up into thousands of tiny little pieces and ignore it completely. That is absolutely their right. The only qualification to that is that couples can come back to us if they have a very, very clear and specific agreement that they want to be converted into a consent order. I'm thinking of the sort of mutual clean breaks type order, rather than anything that requires a sort of hidden element of negotiation. Again, if we found ourselves in that position, I think we wouldn't be able to assist. That rather breathless run through is all I was going to say about our processes and what we do. And so I'm going to hand over to Sam at this stage.
Okay, hi. So I was just going to go through how this differs from other types of ADR, in particular private FDRs, and also the sorts of cases that lend themselves best to it, really. So how does it differ from a private FDR? There are kind of a few main differentiators. The first is that the couples are taking the advice in the advice session without their legal teams. And we think that's a key differentiator because it's really encouraging couples to take control, to engage and take ownership of the negotiation, which will then follow in terms of the concessions they're going to make or not going to make. But the counterbalance against that is that it isn't a process for negotiation. So neither of them are going to be making binding concessions in the room without talking it through with their legal advisors if they want to, and thinking about it quite carefully. The format of the actual advice session is very different from a private FDR. It's much more akin to a con, where the barrister kind of takes the lead and explains the background and the law and how it applies to the facts. The couples are engaged in asking questions, but there's no process by which each are giving submissions or anything like that. During the disclosure process, we get as much as we possibly can out of the couple on paper, so that the barrister has that in advance. So it's not a process where either of them are having to advocate for themselves in the room. And because they're there on their own and because they're not negotiating in the room, that's why the written advice is so important, because it's crucially important that these two people can go away and know exactly what was said, and everything that's said in the room is reflected in the written advice. It's really detailed. And within the fee, we allow a round of questions. So if the couple go back to their solicitors and talk it through and they've got follow-up questions, they can come back to us and we'll make sure those are answered. It builds in, because they're not negotiating in the room on the day, it builds in a period of reflection. And actually for some couples that can be really helpful. Sometimes the pressure of going to an FDR and having to settle on the day, if you don't then settle, feels like a failure. Having the ability to take the advice, think about it, read it, talk to your advisors about it, and then convene a roundtable meeting or go into mediation can be really helpful. And we find that the solicitors that work with us a lot tend to leave a week's delay between the advice coming out and a roundtable meeting, so that their clients can have a kind of think about it, let it settle in, have a chat with their solicitors and talk it through before they then enter into negotiations. The costs are lower than private FDRs, largely because you're not paying for representation on each side. But similar to a private FDR, we allow clients as much as we possibly can to choose the barrister that they want. So we're regulated in a way that we can use any barrister from across the family bar, provided they're up for it. So if there's a preference, then we can always reach out to people, and we always try and obviously get the right expertise for the right case. So that means, again, we're just super keen for clients to get the person that they believe in, so that when they hear the advice, they can really take it on board. In terms of particular cases that this works really well for, I mean, we're obviously most associated with very early stage advice. And we do love getting couples in very early on. But increasingly, we are getting couples who are midway through proceedings. And we're obviously seeing an impact of the cases being adjourned as well, that more and more couples are looking for different options and looking for remote options. And because we've been operating by Zoom for quite some time, we're set up for that. Cases which are most suitable, I mean, you know, obviously you've got one side who's not represented. This is a really good sort of situation for equality of arms, really, if you've got one side who doesn't have a solicitor acting for them. If there's already been a failed FDR, or there's just a general dissatisfaction with the court process, this idea of trying something different that's outside the sort of normal adversarial mode can be really attractive. Those who are particularly cost conscious. And in early stages, if you have a case that comes across your desk and it seems really obvious that it should settle through negotiation or mediation, but there are points of principle that they're stuck on, it can be a really useful way to get over those at the earliest stage, before they become entrenched. I think I'm probably gone slightly over time. I'm sorry, Suzanne. I think if the only other thing we were going to say is if you're interested, or if you have a case that you think might be suitable, Harry and I, because of the importance of the impartiality of the process, we kind of have a front of team staff who deal with client inquiries, because you don't want one of the couple to think that you've been nobbled by the other. But when it comes to solicitors or barristers, we're always here for a chat. So if you have a case that you think might be suitable, feel free to give either of us a call, and we can talk it through.
Brilliant, thanks very much. Really interesting to hear about it. And I hope that you'll have a lot of inquiries in this new time, as it were. Now we're moving on to hear about arbitration, an update on financial arbitration, and that's with Chris Pocock QC. He's a divorce and matrimonial silk at 1 King's Bench Walk. He was one of the first silks to qualify as an arbitrator under the IFLA scheme. And for the last 4 or 5 years, he's been a member of the advisory committee of IFLA, which advises the board on the development of the arbitration scheme and rules. He's arbitrated a number of cases since he qualified, mostly full financial cases. Now, Chris, very carefully and cleverly, wouldn't tell me his new skill, so I'm waiting with bated breath. What is it, Chris?
I didn't know I was meant to tell you beforehand.
You were?
I thought this was all meant to be a surprise. Turns out there's a barrister thing going on, because mine is also a quarantini.
Aha. You can share your details with Sam.
Well, I shall, but just a word of warning that all the recipes that have been floating around on the internet and so on, they don't tell you the most important point, which is if you're planning on having a second, mix it as a batch with your first, because you won't be able to mix it properly once you've had the first one. It's
well, thanks for that top tip.
about a martini.
And also, I'd quite like you to tell us what COVID stands for.
Oh, no, come on.
Come on, Chris.
I came up with this morning. It's courts on video, I think. So in the spirit of that, here we all are on video.
Thank you.
I'll try to keep this to 10 minutes. I shall keep this to 10 minutes. I have a timer running, and if you keep seeing me looking down, that's what I'm checking. Obviously, in more normal times, I would be using a slot entitled Update on Financial Arbitration to talk a bit about the law concerning arbitration and how the court's support for the resolution of family financial cases by arbitration has never been stronger. I would remind you about what our former president, James Mumby, said in S&S. I'd talk about what Mostyn said in JMB. I'd remind you of the guidance in 2016, the family court's interface with arbitration. I would particularly be telling you about two recent reported cases, and there's one yet to come that hasn't been published yet. Decisions of Claire Ambrose, who is a commercial arbitrator who Mostyn J has allocated 3 cases to, and as I say, we've got the reports of 2 of them, BC and BG and H&W, dealing with attempts by litigants who've been through arbitration, didn't like the result, to avoid the turning of the result into a court order unsuccessfully. But anyway, all the courts, all the signals from the judges and from the courts at the highest levels, in the family division anyway, have been in support of arbitration. And I will be telling you how useful that is and how important it is for the process of arbitration that the courts approve. I don't have to do that now because these are not normal times, and I don't have to tell you that you ought to be arbitrating rather than relying upon the courts, because the courts are telling you themselves. We've all been suffering a bit in the last 10 days or so from guidance overload. But better than guidance, there are directions being given applying to all cases by a number of courts, and I'm not going to go through all of them. I only need to refer you to the FRC directions issued last week, which effectively say, don't come to court, find another way. Paragraph 9 of the guidance says parties should make use of private FDR's arbitration and ADR wherever possible. It's the duty, this is paragraph 11, it's the duty of the parties and of the court to consider alternative means of resolving the dispute. The court will need to be satisfied that the parties have properly explored such means. These include, but are not restricted to, number 1, arbitration. Number 2, private FDRs. Number 3, mediation. Where the court is not satisfied the parties have appropriately explored ADR, the hearing will be adjourned so that this may be explored. So we have been told, and as I say, other courts around the country have promulgated similar directions. We have had various iterations of guidance about how to do this in this time of social distancing. And the reasons for all this are pretty obvious. With the rules about social distancing now in place, stay at home unless you absolutely have to leave. Courts as buildings cannot operate, but it's worse than that, because even though many judges are set up with judicial laptops provided by HMCTS, A, they've only got Skype for Business on, which isn't ideal, but B, not all judges have even that. Deputies don't have them, and many courts, particularly the CFC, rely a lot on their deputies. They don't have judicial laptops. Magistrates don't have them. And so local courts around the country are having to pick up the work, insofar as it's urgent, that magistrates would otherwise be doing. The fact is that the court system is simply not set up for remote working, certainly not in the sort of volume they need to be to keep the cases that need hearings in judges. The result is that at the moment, a lot of courts, frankly, but a lot of solicitors don't know how they're going to get their cases determined where they need a determination. Arbitrators don't have the same difficulties as courts do. For a start, we don't need staff to open a building. We don't need staff to organize papers, to bring paper to us. Arbitration still has, obviously, the same advantages that it did before the current circumstances. You can choose your arbitrator. You choose an arbitrator you think knows his way around the sort of area of work, area of law that your case falls into. Some people don't like the idea of choosing their arbitrator. You don't have to. Ask IFLA to choose for you or to choose from a short list. Your arbitrator has more time to read, he has more time to think than most judges because he doesn't have an overwhelming list on the day. You get your decision in writing. The process itself is much more flexible and much more adaptable to the particular case that you're dealing with. It can be anything from a full-blown financial disclosure process, directions hearings, experts, all the way down to the decision on a particular issue on the papers or the whole thing on the papers. And our availability is more flexible than you usually find in the courts. But at the moment, with the particular circumstances we're all trying to work in at the moment, we have extra advantages. We are all set up for remote paperless working. I've not done a case with actual paper in it for well over a year. We are already have already been doing hearings remotely. I certainly haven't done a directions or interim hearing face-to-face. That's all been either on the telephone or by some form of video conferencing. Our chambers, our offices, our homes have access to different and much better video conferencing software, like Zoom, although there have been some concerns about the security of Zoom, but hopefully that will be addressed at some point. Like LifeSize, my chamber certainly has LifeSize installed, but you don't have to be in the building to use it. We can even on LifeSize, and I think on Zoom, you can set up a corridor, a virtual corridor for the advocates to try and bully each other into settlement in. These sorts of things effectively, very effectively, but remotely, reconstitute what you would be doing if you were all in the same building. You don't have to be there. You don't even have to have the particular app that is being used installed. You don't have to pay for it. As long as somebody has the app, they can invite you. You can join on your phone. I've done it. So this is actually something that we are already set up for. And where the guidance, indeed the directions from the FRC tell us, wherever possible, you should be doing something other than coming to court, you might think, well, where is it possible? What sort of cases can we take to arbitration for determination? To which the answer is almost anything. Obviously, full applications for financial remedies, and that can be from a very early stage or can be from a fortnight or a week before your final hearing, which you've now found has been adjourned because the courts can't deal with it. But we can also arbitrate specific issues within hearings. You may remember Mr. Justice Moore decided a case called CM and CN last year, where he was faced with having to determine what would be in an SJE's letter of instructions because the solicitors couldn't agree. And he was, frankly, it's perfectly obvious from the judgment, furious that that had come before him. And he said, why didn't you arbitrate this? Well, you still can. But why not arbitrate a first appointment? The arbitrator will arbitrate what you ask him to arbitrate. You don't have to ask him to arbitrate the whole thing. He can arbitrate, he can decide what directions this case is going to need to progress it back in the court system. And at the moment, the FRC's guidelines are saying, please agree your directions for your first appointment, because effectively we can't hear it for you. Well, you don't have to just capitulate, just come up with some form of agreement. Simply, in order to get the case moving, ask an arbitrator to decide that for you. If you've got an application for expert evidence, fairly obviously under CM and CM, but also interim applications. You can't get your needy client before a court to decide whether the husband should pay or the other party should pay. Interim provision, whether there should be a LASPO order. All these sorts of things can be arbitrated as standalone issues. And at the end of the process, if you've gone through some other form of dispute resolution, you've mediated, agreed 99% of the case, but there's one issue that you can't agree, take it to an arbitrator. Things that have been arbitrated in that way in the past have been chattels. No court likes to deal with that, so let's leave that to arbitration. But other things too, whether there should be a term on a periodical payments order. Everything else is agreed, but we can't agree whether there should be a term, or we can't agree when the term should be. All these sorts of things are arbitrable, and the resolution by the arbitrator will be supported by the court. At the moment, a lot of people are still in, oh my God, my hair's on fire mode. There's absolutely no need. Keep calm and arbitrate. Suzanne. Oh, you're on mute, Suzanne.
Thank you, Chris. I love that message. And we're now continuing with our arbitration theme to hear from Janet Baisley, QC. She's the joint head of chambers at One Garden Court Family Law, a leading specialist family law set in London. Janet arbitrates in both financial and children cases. She's a trainer on the children arbitration course and has been proactive in drafting and promoting the rule changes effective today, actually, 6th of April. And they expand the scope of the children's scheme to include leave to remove cases. So it's absolutely fabulous to have Janet with us here today. Her new skill is apparently yogurt making. So over to you, Janet.
Yes, that's right. Well, this is an auspicious day for children arbitrators because when the scheme was first set up by the Institute of Family Law Arbitrators in 2016, one of the things that was left outside scope was leave to remove, both permanent and temporary. And Suzanne and I were both on the committee that IFLA set up to consider the rules for the scheme. And we were, together with Mr. Justice Baker, as he then was, in favour of leave to remove being included. But because there was such a concern about safeguarding and the focus was so much on safeguarding that it wasn't included at the start. And safeguarding became something that everybody had to deal with as a priority, not least because, of course, in children arbitration, we don't have the use of the CAFCAS officer to deal with the usual safeguarding checks. So safeguarding checks were put in place, and that's the other change to the rules today, because initially, one of the ways in which safeguarding was dealt with was parties had to apply to Disclosure Scotland for basic safeguarding checks against the police national computer and so on, and provide those to the arbitrator, together with a safeguarding questionnaire and a form of referral in which they signed saying that their safeguarding information was true and accurate, and that they understood the ongoing duty to provide updating safeguarding information. Why Disclosure Scotland, you might ask? That was because at the time, an individual couldn't go to the Disclosure and Barring Service, which is the English equivalent. That was limited to institutions. But that today has also changed because the DBS now does accept individual applications. So safeguarding is neatly dealt with. Suzanne and I have been lobbying for some time now for the expansion of scope of the scheme to include leave to remove, because it seemed to us that this was a single issue that was ideally suited to arbitration. Both holidays and permanent leave to remove are a really vexed question in children cases. They're difficult cases, but arbitrators are drawn from those who are judges and who have particular expertise in dealing with those complicated issues. So it does, when we considered how we might do it, and Suzanne, who's on the Rules Committee at IFLA, said to me, you write a paper and I'll put it to them, and that's the way we went forward. We were thinking about what the limitation of scope could be, because clearly, again, it would have to go fairly carefully and slowly to make sure that we didn't get something terribly wrong or there wasn't some disaster. So the 1980 Hague Convention was one thing that was considered as a way in which to limit the scope to cases within Hague 1980. That's great for temporary leave to remove because it's focused on rights of custody, the machinery for summary return and so on if somebody kept a child after a holiday. So it seemed that that had a benefit to the expansion of the scheme to include leave to remove, but it wasn't so obviously relevant to permanent leave to remove, except perhaps as a kite mark of states with a developed system of family law, because the convention bites on wrongful removal and is really designed to maintain the link on a temporary basis rather than to regulate the arrangements for children after removal. And so, of course, we then came to consider the 1996 Hague Convention, which is designed to provide a read-across enforcement from the English decision to the courts of the new habitual residents. So it seemed right then to include within scope not only jurisdictions that were signed up to the 1980 Convention, but also jurisdictions signed up to the 96 Convention. And then, of course, we came on to consider the EU complication, which is that whilst we're still signed up to Brussels 2 bis, that regulation provides for direct enforcement between member states of the EU, except Denmark, of course. And as between signatory states, it displaces Hague 1996. So we then devised a new rule which said that leave to remove is outside scope, except to jurisdictions which are signed up to and apply the 1980 Convention, the 1996 Convention, or Brussels 2 bis. So we now have a wide-ranging scheme. The other advantages of using the various conventions is that the 96 Convention applies in the States, 1980 applies in Russia, so one's now got a pretty broad jurisdiction in relation to leave to remove, which Suzanne and I are pretty convinced is going to really enhance the take-up of the scheme. It's quite easy to refer to a children arbitrator under the scheme. It's suitable both for represented and unrepresented parties. An independent social worker will be used to convey the children's wishes and feelings to the arbitrator in the same way that CAFCAS might in a case proceeding through the court. There are enormous advantages in terms of speed of decision, and in particular in our current situation in lockdown, one of the other enormous advantages, it seems to me, is that there can be determinations on paper. And although not many people are flying anywhere at the moment, one can see that a holiday, for instance, is a particularly useful way to deal with it on paper. This seems to me to be something which will really move on children arbitration exponentially. And just anecdotally, I was delighted to hear that the scheme approved. Suzanne put it to IFLA following the paper, and I'm told that Sir James Mumby, who is an honorary member of the committee, pretty much said, well, Suzanne knows what she's doing, so if she's happy, I'm happy. And it went through. And we look forward now, therefore, to doing leave to remove as part of our children arbitration work.
Thanks very much, Janet. I really hope that people listening will think about the cases that they have going on at the moment and think about how they can you know, pass them out to arbitration, both financial and children. Now we've come on to a very exciting part of the webinar today, as a panel discussion regarding private FDRs. And we have 4 panellists. I'm going to introduce them all. I hope that Mr. Justice Francis is here. Oh, good. He's in the room, as we say. He's in the room. He's joining us as he's a family division High Court judge, has been for 3.5 years, known to us, to many of us as Nick. He has been conducting a Skype for Business hearing before joining us this afternoon. Before his appointment to the bench, he'd conducted a large number of private FDRs and was one of the early pioneers of this form of ADR. Nick, what have you learnt about yourself since we've been in isolation?
Well, I think the most amazing thing is I now love the Xbox. I used to sort of complain all the time that my children spent too long on the Xbox. Now we say thank goodness for the Xbox. It keeps them occupied. I've also decided I prefer the radio to TV.
I agree wholeheartedly. I've stopped watching the news apart from the briefing at 5 o'clock. Nigel Dyer, QC, I hope he's in the house.
Yes, he's here.
Nigel has been practicing in money divorce work for many years and has been involved in many of the leading cases. He also has a practice as an FDR judge, and over the last 4 years he has done over 120 cases in this country and abroad. He has done 2 virtual FDRs since the lockdown, and we'd be interested to hear about that, Nigel. And what have you learned?
I've learned that there are no comfortable chairs in my house to sit at for the whole day in front of the screen. I'm on my 5th chair and they're all really uncomfortable, and if I had a chance I'd get back to Chambers and get my decent office chair.
Brilliant. And is Nick Allen QC in the house?
I am, Suzanne, yes.
Brilliant. Nick Allen is a matrimonial finance specialist at 29 Bedford Row in London, and also St Ives Chambers in Birmingham, where he's a door tenant. He sits as a recorder in the family court hearing finance and children cases and is collaboratively trained. He regularly hears both private FDRs and finance arbitrations, and has now been appointed as arbitrator in approaching 20 cases. And Nick, I think there's a theme going on here. What have you learned?
Well, I've learned that it's possible to survive on a diet of gin and wine gums, and I've managed that for 2 weeks, and I intend to do it for as many more weeks as we're all stuck in our respective homes.
We're looking forward to seeing you at the end of this then. Marina Facinato, are you in the house?
I am.
Brilliant. Marina is a barrister and arbitrator specialising in financial cases, Schedule 1 finances on divorce and dissolution, court of protection and inheritance. She's pragmatic, I can vouch for that, and encourages out-of-court settlement where appropriate and arbitration where it isn't achieved. Now, you've learnt a few things about yourself, haven't you, Marina?
I have. I've learnt I'm a real creature of habit. I've discovered that I miss that every morning walk up Middle Temple Lane with a particular colleague from Chambers as we rehearse the points that we're going to make or not make. I've also discovered that my children are incredibly persuasive. My husband instituted a pull-up challenge about 2 weeks ago, and he's put a scoreboard up on the wall, and I've discovered I am as competitive with my 5-year-old as my husband is with them, as we're desperately trying to lever ourselves up over a pull-up bar, which is a little embarrassing, but there we are.
Thank you very much. So without further ado, I just wanted to start off with some questions of each of the panellists before getting all 4 together. Starting with you, Nick Francis, you've had experience of conducting private FDRs as a barrister, then acting as both a private FDR and obviously a court-based judge. What's your view from the bench? How should practitioners prepare for a private FDR?
I think preparing for a private FDR is particularly different from preparing for a court-based FDR. You've still got the same job to do, but the first thing is to tell your clients what's going to happen. It amazes me how many people come to an FDR and don't know what's going to happen. When I'm sitting as a judge dealing with them, the first thing I do before counsel stand up and pontificate, I tend to explain to the parties what the day's about, tell them that they can have a break whenever they want to for a cigarette or a coffee or whatever it may be. That they can interrupt if they want to, and that it should be much less formal than court. I think that's very important to explain to the parties. I think it's very important to explain to the person who's the applicant that they shouldn't feel rushed, that they shouldn't feel under pressure to do a deal that they're not happy with. And one of the things that always gets me cross as a judge is if somebody says, I'll make you this offer, but it's only open till 4 o'clock this afternoon or something like that. I think that's intolerable pressure. And I always start, again, when I'm the FTR judge, by saying, please don't play those sorts of games. If an offer is worth making today, it's worth leaving it open tomorrow as well. It's not unreasonable to give somebody a week to think about it. I think quite important. I mean, as counsel, what you have to do to prepare is obvious. You prepare a schedule, you prepare a note that's concise. I get pretty cross when I get 25 or 30 pages of notes from counsel for an FTR. I just thought 10 is enough. With a schedule, I'm very keen on having one schedule. So if there are 2 or 3 or however many parties, I prefer the A3 schedules. Different judges like different things. HMCTS can't afford colour printers, so please bring one to me, because if it's a court-based FTR, because I quite like to see the colour. But one schedule with differing from people's contentions on it, I think, is much easier than trying to put 2 schedules along side by side. So just a few starting points. I'm actually pretty cross with Nigel Dyer, because I used to say I'd done more private FTRs than anyone else in the world. And I had done, I think, 101, but you now tell me he's done 125, so it's quite annoying.
Oh dear, there's always this competitive rivalry, isn't there? So let's turn to Nigel at this point. Nigel, you've conducted numerous private FDRs. What do you think are the most suitable cases? Which cases really lend themselves to being dealt with by way of a private FDR? And any distinction between that and arbitration? So I've used many questions, as we're seeing the press do with their the press briefing at 5 o'clock. I've rolled them into one for you.
Yes. A minestrone of questions.
Exactly.
I think, first of all, FTR is very suitable for those cases where parties wish to settle, but there are certain issues that they can't agree upon, which obviously impact on either the quantum or the format of the order. I do think there needs to be an expectation of settlement, but they simply can't they simply can't push the ball up the hill. I mean, there's sort of issues that commonly come up. I'm sure we're all aware of them. It's often things like the impact of premarital property. That's an old chestnut. Post-separation accrual, if there's a long delay after separation before coming to court. Then obviously earning capacities, housing needs, duration of maintenance. Those are the standard issues that can be evaluated, I think, quite accurately by a judge. It's perhaps easier to say which cases are not suitable for FDR, and I think those cases that are, I think, probably obviously there but in a minority, are obviously ones where there's a serious allegation of non-disclosure. I don't think they're really ever suitable for FDR. Compared to arbitration, I think arbitration really is the next stage. I think if you're going to have arbitration, that should mean that you haven't been able to settle at a private FDR or an FDR in front of the judge. I think obviously the advantage of arbitration is you're going to get finality and the end of the case just as you would do if you had a contested trial before a judge. So I do think they're different but complementary processes.
Thanks very much. And now turning to Marina, you've had a lot of experience as a barrister preparing for private FDRs. What do you think the practitioners should think about when they're in this new normal, as it were, of dealing with virtual hearings? And have you done any virtual private FDRs? What's your experience, essentially?
I've done 3 private FDRs in the last 2 weeks, and I suppose my experience of those informs the answer to your first question, which is what we need to think about. I think there are 2 separate sides. There's the advantages of the technology, and I think there are real advantages that you can embrace. One of the joys of doing it in this way is that you can be in much less doubt about what your judge is looking at. There are all sorts of facilities on these various applications. You can share your screen, and the joy of that means that you can pull up a cartoon, as I have done for the New Yorker, or as I did last week, a video of the former matrimonial home. So when the wife was saying that it was at a certain standard and the husband was saying it was a different standard, the joy of being in this virtual world means that you can take advantage of that technology. I think the other thing is to do with preparation. We all know that when we're preparing, there's a sort of the legal side of preparation, our asset schedules, the cases, the bundles. Many of us have been e-bundles for a while. But virtual FDRs require a slightly different preparation of the clients, both lay and professional, in terms of the logistics. And so what I've found is that you need to have quite clear protocols for how you are going to manage the hearing. Part of that will be how the judge is managing it, who's hosting it, and how the breakout rooms work. But I've also found that I've set up very clear protocols with my team, which is the moment we leave the judge, we will assemble at such and such a virtual place, so that we know, and I've talked the client through how that's going to work, because I think they can otherwise feel a bit abandoned. They're managing this process from their own space. They don't have solicitor sitting next to them. And so I found that it's quite important to agree how that's going to work. And the other thing I would bear in mind is most of us aren't used to sitting in front of a computer screen all day long on our own. And so not forgetting tea and lunch and coffee. Now, of course, I can't make you a cup of tea and I can't invite my clerks to make you a cup of tea, but I can say, now's a good chance to go and do that. Let's all stretch our legs for 5 minutes and go and do that. Because actually, I mean, for example, Friday's FDR finished at 7:30. You're always tired after an FDR. But when you've been managing the interactions through a computer screen and a telephone to do your negotiations with counsel and a separate protocol to do your emails or whatever it is, I think it's worth bearing in mind the toll that this wave of blue light and sitting hunched over can take on people. So I suppose that's the sort of bolt on to ordinary FDR prep, is to really think about the medium through which you're conducting what can be quite a stressful day for lay and professional clients.
Thank you very much, Marina. I think I've currently frozen, so I'll take the opportunity of defrosting myself whilst Nick Allen speaks to us. Nick, again, you've undertaken numerous private FDRs. Can you tell us what you think we should be avoiding, what we shouldn't do when we're doing a private FDR? And also, I'd be interested to know what you think about the suitable cases for mediation. When should we be mediating?
Well, can I just say at the outset, Suzanne, that I'm feeling the pressure of my former pupil master.
As you should.
When I've got the Honourable Mr. Justice Francis staring at me on my screen, it always ups the pressure, perhaps even more so than when I'm in his court. But in answer to your question, when it comes to a private FDR, you can assume, and of course you should assume, that the judge has pre-read. And of course, that is very different to the standard court list where your FDR judge is juggling 4 or 5 FDRs and then has very little chance to pre-read. And so my experience as a private FDR judge is what that judge wants to do is for the parties to start negotiating. And that is actually often the key pressure that the private FDR judge feels under. So my recommendation is don't spend an hour, 2 hours on the morning of the private FDR trying to agree with the other side the schedule of assets if it hasn't been agreed beforehand. Nick Francis made the valid point about trying to sort that out in advance of the day. Don't spend the first couple of hours of the private FDR having your pre-hearing con. The private FDR judge wants to get on, hopefully be ready for that 10 a.m, 10:30 start, so he or she can express their views on the key issues and then give you the bulk of the day to negotiate. I think what is an interesting issue, and it's good actually to have both Nigel Dyer and Nick Francis on this event, is that, because I think they may take different views, is whether as a private FDR judge, it is better to give your indication by way of a bracket of likely outcome, whether it is better to give your view as to where the strengths and weaknesses lie on particular issues, where the risk is as to whether you're likely to win or lose, we all hate those terms, but on a particular issue, or whether it is better to actually give a precise figure that you think the capital will be X, the income will be Y, the pensions will be Z. And I think it's probably fair to say, in my experience of doing private FDRs in front of both Nigel and Nick, that they perhaps take slightly different views in that regard.
Nick, stopping you there, because we've got enough time.
Sure.
What's your view in relation to that? And then I will ask the panel, because I think that is a really interesting point.
I shade in my own personal view is it's better to give the bracket. It is better to give the range, because we all know that if there are 10 issues that are between the parties, they may win on 5, they may well lose on 5. They're not necessarily going to win on the 5 that they most want to win on. So highlighting that the 10 issues come as a package and where the strength and weaknesses lie within those particular issues, I personally think is the better way forward, but I know that's not a universally held view.
And Nigel, what do you think?
I never give a bracket. I always give a precise figure on, and I give a precise yes or no, you're going to win or lose. I think that promotes settlement rather than more argument. Okay. I think everybody knows what the bracket is. The lawyers know what the bracket is. I think they want to know where in the bracket a judge is likely to come down. I've actually done some sort of research amongst people who've appeared in front of me, whether they prefer that, and they've all said yes, because it enables you to actually settle quite quickly. If you both say, well, we've heard what you've said, we'll go with that if you go with that. Otherwise, if you leave a bracket, there's always more room for arguments.
Okay, and Marina, what do you say?
I think by and large, my advice to my client before I go into a private FDR is, we've picked the judge or agreed to the judge. I trust their judgment. It would take a great deal for me to be saying to you after he or she has given his indication anything other than, look, let's do that and let's tell the other side pretty quickly we're doing that. I think the only time where that, I would caveat that slightly, is if there's a really thorny issue and one can ask the judge to give a bracket and their answer, because there are those elements of cases where there isn't such a clear-cut answer. I agree with Nigel, the lawyers know the bracket, but sometimes, and indeed perhaps often, the FDR isn't about the lawyers knowing the answer, but about the lay client knowing the answer, because their solicitor, their advocate hasn't been able to persuade them to get themselves into the bracket. And so sometimes I think there is space for on one element, perhaps for there to be a bracket, but with the judge saying, in fact, my judge was Duncan Brooks on Friday. He said, on this aspect, there is a bracket. My answer would be X, but you two may find a different way around it. So a hybrid. But by and large, I like the judge to say this is the answer.
And Nick Francis,
unless they don't agree with me.
Nick Francis, would you like to give us your view, or would prefer not to?
I'm very happy to give you a view. I think that it's not always easy to give somebody an exact answer, because there isn't always an exact answer. We all know perfectly well that 3 different judges with same facts could have 3 different results, none of which is necessarily wrong or right. So I think give somebody an exact figure is not always right. You see me, by the way. I've got Marina frozen in front of me.
I can see you.
We can see you, Nick.
We can
see Marina holding her ear in a very particular way. She's come back to life. I mean, for example, if you're looking at something like housing need in a fairly big money case, I mean, there could be an enormous gulf between the parties, and I don't think there's an obviously correct answer exactly between them. I also don't necessarily agree with when Nigel says everybody knows, the lawyers always know what the bracket is. It astonishes me how often with an FDR, each side is outside the bracket on their initial position. Now, I know what they're saying in their FDR note. It's not necessarily their final word. And very often they're not going to talk to each other until they've heard what the judge says. But it astonishes me how often people their pitch outside the bracket to begin with, and you've got to talk them into it. And sometimes it's your own client who's being difficult. Certainly when I was at the bar, I was sometimes quite relieved when the judge was against me, because it meant that while I was telling the client could accept that my advice might have been right. So it's not always going necessarily the way you want it to. So I think it depends on each situation. What I try and do is highlight what all the issues are. And I'll go, once I've finished hearing from counsel, I will say to them, right, I think these are the issues, to agree, and they'll either say yes, or maybe there's something else. And then in relation to each of those issues, I will give them my opinion. And some of them may be small, and some of them may be big. Also, I always think very important, even if somebody is going to come out rather badly from the FDR, I like to think of it as you like to give them something to take away that they've done well on, so that at least they feel they've taken something away with them that they've gone on a point. But what I tend to do is I'll answer all of the issues, and then I'll say to them, now go out and have a think about where you are and see whether you can resolve it, having heard from me on those issues. For example, whether to include or exclude premarital contribution. If I say, right, I don't think you can include that because that £1 million was received last week, take it off schedule. they can go and have another think about how to look at it. I don't think it necessarily leads me as a judge to an exact figure. I think it enables the parties to go away with what you've said and recalibrate their offers. So on that, I don't necessarily agree with Nadia.
Thanks very much. A good diplomatic answer, I'd say. And Nick, sorry, I interrupted you mid-flow. So I wonder if you're happy to go back into this.
Well, I was sure. I was going to pick up actually one of the points that Nick Francis has just made when it comes to housing particulars and housing needs. Now, obviously, Nick made the comment in the context of a big money case, but we're all used to the battle of the housing particulars in the more modest asset cases. And at the risk of stating the obvious point, it's amazing how often parties simply identify properties that they think are suitable for themselves and think are suitable for the other party. And of course, there's a massive gulf in prices between those two. And if you're, as a tribunal, seeking to identify a figure between those figures, you're left with little more than guesswork. So I would always recommend to parties preparing for a private FDR, even if you've identified the properties that are suitable for you, the properties that are suitable for the other party, at least identify what you get for your money between those two sets of particulars, so the court has got an idea. Although my experience of doing private FDRs in front of Nigel Dyer is he always announces that he has an intimate knowledge of whichever part of London the parties are talking about rehousing. I don't know whether that means all my private FDRs involve the same part of London, or whether Nigel has some kind of itinerant history and basically wanders London and the southeast.
Thank you. And back to the point, Nick, if I may, about mediation. Can you address that point?
I mean, I'm not a trained mediator, Suzanne, so my answer has to be caveated, and there are a number of people taking part in this event who are mediators and who've obviously explained the differences between various forms of non-court-based dispute resolution and mediation. But I would say that mediation requires trust between the two parties. It requires, hopefully, a quality of arms, an understanding of that you trust the other person, and that there's going to be, nothing hidden. People are going to be willing to put their cards on the table. The more there is the inequality of bargaining power, the more that one party has held all the, has kept the family finances completely secret to themselves during the course of the marriage, the more the other party is playing catch up, the more difficult I think it is for mediation to succeed. But that's my perspective, Suzanne, from a non-mediator point of view.
Thanks very much. I've now got a question for each of the panelists, and that would be if you could just distill to a couple of sentences your top tips for virtual dispute resolution. It doesn't have to be private FDR, just any type. I'm starting with you, Nick Allen.
Oh, I think the key, it's one of the points that Nick Francis has made. I think identify the issues, don't begin with loads of waffle, be very clear with your team what issues you want the judge to give an indication on, give the judge the information they need to determine that view, to give that view, and say nothing more. And my other point, Suzanne, is I don't know those of you who saw the guidance from the Court of Appeal in terms of virtual hearings last week. They suggested that you purchase some kind of neutral background, some kind of screen. I don't know how many of us have yet tried to go on Amazon to buy a sort of neutral screen that we can put behind our chairs, but that certainly appears to be the Court of Appeal top tip.
We'll all be racing to do that now, and they'll run out quickly. Marina, what do you think?
I think it comes back to anticipating how the day is going to unfold. And so building on what Nick has done, so you've done your fantastic presentation to the judge using all of the technological advances that we've got, but it's having planned with your clients what the likely next steps are going to be, because those interactions are just not as fluid when we're doing them in this way. So having an agreed schedule that everyone's working from, anticipating what the judge is going to say and allowing you to make those moves, and having agreed how those exchanges are going to happen. And I have to say, I suspect that the Court of Appeal needing a Amazon background probably means they haven't discovered two quite useful buttons on Zoom. The first is a virtual background, and we can all have a play around with that. And the other is my top tip. Whilst we are all exhaustedly juggling all the balls we're juggling, there's a very good button which I've pressed, and I suggest I'm not the only one, which is touch up my appearance. So certainly Zoom will do your makeup and your hair for you. Just click the touch up your appearance button.
You should have shared that before. I can't believe you're telling me that. That's outrageous. Okay, so can we now hear from Nigel and his top tip?
Yes, I've got three. First of all, I think you really, as a lawyer, you need to understand and make the most of the technology. The second point, something I've actually found as an advocate and as an FDR judge in the last few weeks, is that I do think that when solicitors prepare the bundle, that they must try and prepare an electronic bundle like you would have for court. I think I did an FDR last week. I got something like six or seven different PDF attachments. I think, bearing in mind the direction about having an electronic court bundle now, following specific guidelines, I think we ought to aim to do that for private FDRs. It means there's one bundle, and also it's searchable. I think that should follow. My last point, the third point, is I think all the lawyers need to prepare well in advance for the hearings, especially private FDRs. I think I would certainly urge cons being earlier than perhaps they are. I think you need to, because of the time you need to spend, because of the technology you're coping with, I think you need to have your clients full instructions on things. I think that's somewhere that I've found quite difficult, to actually engage the client in a way that you really can't do when they're sitting in a room next to you. I think book those cons in earlier, and if you're going to make an offer, make sure you make it as soon as possible. Don't wait until the day of the hearing. I think that is guaranteed to just delay the whole day and probably not result in a settlement. So prepare well in advance is my third point.
Prepare. Nick Francis, have you got any top tips for us?
One of the things as judges that we've been concerned about with virtual hearings, and I've been doing them now for about 2.5 weeks, is the risk of misuse of recordings. Obviously, we tell people that it's a criminal offence and publish and so forth. If you've got a couple maybe who are in an abusive relationship where somebody has been used, and there is a real risk that the recording, even in an FTR, that it could be used against them if they didn't like the result. So I think it's very important to warn people of the risks of using that, and it's a much bigger risk in, say, a care case, which I'm a lot of now as well. So I think that's quite important, just to remind people that although the Zoom process is recorded, it would be a criminal offence to show that recording to anybody else. I think it's quite important that they remember that, of course, they're lawyers. I think the second tip is don't have a dog in the room when you're doing anything. It's pretty irritating. Mr. Justice Mostyn doesn't agree with me about this, obviously, because he's got Bilbo. I think one thing I haven't had to do, because I can't negotiate with people anymore, I just tell them. I should think negotiating must be quite difficult, negotiating remotely. If you know each other, like most of us on this call know each other, that's probably easier because you've got that sort of knowledge of somebody, you've got that friendship. But if you're against an opponent you don't know very well, I think it must be quite difficult to have a smooth negotiation. And I think that if it was me, I would want to talk to my opponent before private FTR started. I don't just mean that day, but I want to get together and have a chat about how we were going to do things, hoping that I had somebody reasonable on the other side and we could agree how we were going to do things. And that would include things like an agreed chronology, an agreed schedule, or, as I say, one highlighting the differences if they can't be agreed. I think you need far more cooperation when you're doing things online than you do if you're just going all of you into a room together.
I agree, and I think having those virtual teas and coffees are imperative. So we sort of started going on to the concerns, and I think there are a few concerns about virtual DR. I'd like to just highlight those concerns if you would, and also, are there any ways that we can overcome them? Marina, what do you think the concerns might be?
I think from a practicing advocate, I know that others will deal with the concerns about in the household, but it's the protocols and the etiquette around it. When you're at court, most people know to go and hammer on the other side's door to say we're going. and there's a much clearer structure around the time of the day. So I think for me, doing them remotely, it's agreeing, as Nick's just said, picking up a timetable, a protocol, an agreement for how it's going to happen, what the day is going to look like. On Friday evening at 5 to 7, I sent my opponent a text message saying, I've sent you an email, my client's tired, your client's tired, what are we doing now? In a way that's much harder to do in this virtual world than actually going and collaring them and saying, look, it's 7 o'clock in 5 minutes, we're going to draw stumps. So I think from the advocate's point of view, if you're judge, and so when I sit as a private judge or as an arbitrator, it's one of the things I'm concerned to set up in advance is that the housekeeping structure of the day. We will start at this time, we will have a break at that time, please do say if you want a break, and just having everyone's contact details so that you can call people and not just relying on the system that's been set up by whichever court or whichever set of chambers. So trying to bring a level of structure and formality to the day to give people that confidence with how the day is working. So to say no one is expected to be in this breakout room now because we're all stretching our legs. And I think that's something that it's important to set up from the start of the day so that we can all cope with the demands on us of this attention to a small screen for whatever it might be, 10, 12 hours.
Thank you. And Nigel, the same question to you.
I think the most obvious one is just purely as a result of where we are at the moment with the lockdown, which is couples being in the same house, having to deal with the hearing in adjacent rooms. I think that potentially could give rise to the more dominant partner, let's assume it's the husband's, becoming overbearing, perhaps aggressive during the course of the day. Of the 2 hearings I have done in lockdown, the wife in each case went to her solicitor's office where she was sat in a room in front of a screen. So I haven't had that experience yet of couples being under the same roof whilst the hearing goes on. But I think that would be something I would be concerned about.
And do you think that we can do anything about that? For example, would it be helpful, I mean, there'd be lots of solicitors listening to this today, would it be helpful if the solicitors had some form of screening, as it were, to assist the barristers and therefore the private FDR judge in those circumstances?
Well, I think the solicitor obviously needs to be in regular contact with the client during the course of the hearing, you know, by WhatsApp text or something like that, where the client can actually, you know, raise the red flag if there's a problem with their spouse. I think that's important.
Okay, thank you. And Nick Allen, what are your concerns?
I think really it's a development of Nigel's point, because even if the spouses are not under the same roof, you as the judge, private FDR, judge arbitrator, you want to make sure that the only person who's in the room should be in the room. Mm-hmm. So I think there has to be a checklist that you go through at the start of the hearing if you are the tribunal. Is only the people in the room, the people that you want in the room? Can everybody hear? Does everybody have the ability, as Nigel said, to communicate with their counsel, with their instructing solicitor, so they can give instructions, so they can take advice? That they know that they are to make it very clear to the tribunal if any of those things change at any point during the currency of the hearing, because what might be the position at the start of the hearing may not be the position an hour or an hour and a half further in. I think the point was made earlier by somebody that everyone needs to feel involved in the process, which is much more difficult when everybody is a sort of postage stamp size on a computer screen. So if somebody wants to say something, how do they get the attention of the tribunal? Is it raising their hand? Again, these are things that I think spending 2 or 3 minutes at the start of the hearing, so everybody understands the rules that the day will abide by, is very important, because at the end of the day, it is the lay party's process, and they have to feel comfortable, they have to feel involved, and they have to feel ultimately comfortable in making long-term decisions.
There's quite a useful line, sorry, there's quite a useful part of the order that are being promulgated that requires participants in virtual hearings to certify that they are the only person in the room and that they're not being overheard and they're not recording it. And it's quite useful to be able to just fall back on that. So when you're setting up the hearing, to say, to just repeat the words, or ensure that everyone certifies in accordance with those words. I appreciate, as has been said earlier, you are relying on people to do that honestly, but in these circumstances, I suspect we'll take good over perfect, with the warning that Nick Francis gave earlier about these recordings will exist, and we need to be alive to that.
And Nick Francis, you'd already shared some concerns. Do you have any others?
No, I think the risk of coercion is really important, and it's quite useful if you know in advance whether, even though you deal with conduct normally these days, of course, but in a different context, you'd want to know if your client believed that he or she had been subject to coercion by their spouse, because that might be going on in the house, just as Nigel was talking about. If they are in the same house in these remote hearings, it's quite useful to know in advance whether there's been a history of coercion, which is what I think we would be very worried about. It's not every private FTR that everybody, and I agree that if they've gone for a private FTR, it means they probably want to settle. It doesn't necessarily mean they get on well enough together to be able to trust each other, being just a few feet away from each other, separated by what may not be a very thick wall. But I think I really echo the point Nigel was just making about that.
I suppose there's also the other end of the day, Suzanne, sorry to jump in, which is, what if you reach an agreement? How do we sign these things? What is the protocol for getting an agreement recorded where you don't have junior counsel trotting around with a scrappy piece of paper and a pen, or an iPad and a pen, as the case might now be? And so that, again, is part of the protocol of setting these things up. Because it'd be a great shame for everyone to have invested in the day, for us all to agree there's been a conclusion in this way, but then not to have some safe record of that.
Well, the safe record is the recording, because if each of the, you've got counsel on both sides, if each counsel say to the judge, we've got a deal and here's the deal, and the judge says, well, I agree, that's the best evidence possible of your agreement, isn't it? And we are dealing now all the time with without the need for what we call wet signatures. I mean, whether it's a divorce petition or a consent order, we've now got new rules to allow for those to be done remotely with electronic signatures, and that's the new way.
I do think, picking up on Marina's point, we all know the advantage of private FDR offers being made in writing. A summary by email sent between counsel, headed W's offer or H's offer and the time that offer's been made, rather than standing in the corridor scribbling down and then it becoming Chinese whispers by the time you've summarised what the other side's offer was to your own solicitor and client. So I think it's inevitable that in the virtual world, post FDR offers on the day are going to be made in some form of writing, probably, and that I think minimises the chances that both parties think they've agreed something different, and hopefully at the end of the day there's a final version of that email that the parties can all say, yes, that's the deal that we want the court ultimately to approve.
I mean, what you actually want to do is take Nigel Dyer's piece of paper, scribble out indication and write W's offer or H's offer on the top. That's an ideal world, isn't it?
But Marina, the other issue we all have with Nigel, of course, is when you go back in and get your indication from him, his piece of paper is face down on the desk in front of you. Straight back to that A-level experience where
I know.
To say,
I've been trying to work out how to
turn the paper over.
All right, thank you very much to all the panelists there. I'm going to do what we say we're doing in a virtual context and have a 1-minute break, because we've had quite a lot of questions coming in, and what I'd like to do is just give everyone the opportunity, all the people who are listening, to raise some more questions so that we can race through as many of those as we possibly can. So 1 minute and we'll all arrange ourselves on your screen ready to answer your questions. So please make sure that you use the question and answer function and send us yet more questions. We've got 8 already, but we'd like some more. Thank you very much. That signifies the return of school. So dealing with some questions across the panel, please. can I please ask, for Karen Walker, how many lawyers are involved in a hybrid mediation? Is it a round table with a mediator?
So in an ideal world, both parties would have their own solicitor. You can involve counsel as well if it's at the level that requires that. You wouldn't have a round table meeting necessarily, but the mediator would meet with both parties' solicitors probably at the outset, just to get a feel for the case and what's going to be required. And then the solicitors would add support to their particular client through the process, sit in on the meetings with the mediator, the separate meetings with their individual client, meet with the mediator and the solicitor on the other side as and when required. And hopefully, if agreement is reached at the end and proposals which everybody's happy with, rather than having the memorandum of understanding to be thought about and maybe unravelled, you've got your legal representation there, so they can actually do the deal there and draft up the consent order.
That's brilliant, thanks very much. And now for either Julian or Nadia, how widely available will the Certainty Project be?
It'll be very widely available. It's open to any who want to join in. Prior to this, we were doing a series of rollouts throughout England. That's now not happening because we obviously can't get together. But for example, if once you've read the materials, this interests you, you know a solicitor that you work well with, or a barrister you work well with, or an arbitrator you work with, a mediator you work well with, engage them, see if they're interested too, road test it. It's a structure that's being rolled out. You don't have to do any courses or anything to join this project. It's a different way of working.
Yeah, you can, I mean, I think you can essentially create your own panel of solicitors, arbitrators, mediators that you know that you can work well with. And I think one of the things very important about the Certainty Project is that you really should be looking to engage other lawyers who subscribe to Resolution's Code of Conduct, because I think that was very much one of the guiding principles of the Certainty Project.
Thank you. And I think for all of the panellists on the private FDR, I think this is going to happen quite a lot. What can you do if you have a financial remedies case, e.g. for directions, FDR and final hearing in April and May, but the other side will not agree to a remote hearing, whether that's a private FDR or whatever, because it's a delaying tactic? Is there anything you can do?
I've got that very issue at the moment, actually, where the order at the first appointment had been that there would be a private FDR and then restore to court for directions, the normal sort of order we're used to seeing. The husband, I think, on the other side is intent to delay the case as much as possible. And this is obviously just the environment he wants to be in. What we have decided to do is to go back to the judge, High Court judge, to get him to direct that there is a private FDR, or alternatively, if possible, alternatively on the dates when we've got set aside for the FDR to see whether a court FDR is available. I'd be interested to hear what Nick Francis says about this, because I can't imagine I'm alone in having this problem.
Marina, do you have a view since you're in the screen?
I think it is a problem. I've had it happen already to me in the last 10 days. And in fact, Friday's FDR was supposed to be an FDR the previous week, a court FDR the previous week, and the other side prevaricated and prevaricated, prevaricated. It's one of the few areas where certainly the Central Family Court's robust guidance has been quite helpful, because we fired off a pretty stroppy letter saying, you've got to be kidding, the courts have made it absolutely clear. If you want us to do a paper application in front of Martin O'Dwyer to explain the circumstances, then on your own heads be it. And you get something of a capitulation to it. But it is difficult in the circumstance. It is something of a charter for those who don't want to proceed with their cases in a constructive manner. You need...
Suzanne, don't forget, of course, that the court has got some pretty robust case management powers under Part 3 of the FPR. But it's either 3.3 or 3.4 that says the court has got the power to stay court proceedings in favour of the parties finding out information about non-court dispute resolution. And I think that if you've got one party who's, you know, trying to drag their heels and isn't playing ball with the guidance from the CFC that Chris Pocock and Marina had adverted to, get the court to use robust case management by exercising those Part 3 powers.
Yeah, I agree. I've got a question here for actually the whole of your panel. What percentage of the private FDRs you have undertaken have been successful, and how in the current climate will unsuccessful private FDRs be dealt with by the court? So a bit the same sort of question at the end, but you know, just to say, broadly, have your private FDRs been successful, panel?
Speaking for myself, I reckon the success rate was over 80%. You've got to bear in mind the people who are paying for private FDR are probably more keen to settle than people who are forced to have FDR. I do wonder, to deal with your second question, at the moment what's going to happen, because I suspect that an awful lot of businesses are impossible to value at the moment, and so are a lot of houses, and people are losing income. So I should have thought it must be very difficult to settle cases at the moment, given the actual calamity that the country's facing.
Yes.
I do wonder, Suzanne, whether the settlement rate has dropped a little bit in recent months and years. And it reminds me of when court-based FDRs came in the pilot scheme in '96, and then of course went nationwide in 2000. And to begin with, we all had, oh, this is a judge telling us what his or her view is. That must be the answer. And we almost all settled at the FDR because it was novel and we were getting an indication. And then in the intervening 20 years, we've got much more used to not settling at court-based FDRs. And I wonder if we're beginning to see the same happening with private FDRs as people get more used to hearing an indication but not necessarily feeling that they have to sign up to it. I saw, Marina, you were nodding there, I think, when I started that answer.
Well, I was saying, certainly my experience in the numbers, I guess it's slightly finger in the air, but I agree with Nick. 80, maybe 90% of my private FDRs at which I'm an advocate would settle on the day, probably with typed up heads, if not a typed up consent order. My experience of the last 3 virtual FDRs I've done in the last week is we haven't settled brackets yet. I think there are 2 elements. One is the inherent sort of economic uncertainty, but also I'm still keeping my fingers crossed that Friday's FDR will settle, if not today, tomorrow. It just takes a bit more time when we're not all able to bash heads together the way you're physically able to do when everyone's assembled in chambers. And there is delay. You know, ordinarily I'd go and hammer on Harry Oliver's door and say, what's taking so long? Now I have to call and wait for someone to put me through. And there is that scope for delay. And I think we have to disentangle 2 issues. One is the sort of the economics, the world our clients are living in, the valuation issues, and then there's the structure of virtual justice. I don't mean virtual justice, but doing justice in this online way. I don't think the second should, after we've all got used to it, be a problem. I think this will be a structural change to how we see our clients. The idea that clients are now going to pay for us to go up, to travel to them for a con, or waste their time traveling up to us for a con, I just think that era is over. We're going to do a lot more in this way. But for private FDRs, there is, I guess there is still that magic of us all assembling, desirous of settlement, even in the tricky cases.
Thanks very much. And now a question for the arbitrators amongst you. Should the bar for appeal for arbitration awards be lower so as to remove one of the perceived disadvantages of the process?
Good question.
As an arbitrator, I have to say I've never. I don't think it can be. The bar is what the bar is. You are arbitrating. You have signed up to a process that is governed, regulated, and restricted by the Arbitration Act. So it is what it is, and it won't change. The more recent decisions have made it. Well, I suppose some people may have thought that it has made it harder to appeal, but what the decisions have actually done is just state what the law is that perhaps people didn't necessarily, or some people didn't realise. But this this I've heard as a put forward as a disadvantage or a reason for potential reluctance to arbitrate is that appeal is much harder. It seems to me to proceed on the basis of a misconception about how easy it is to appeal a judge, because it's not.
Yeah.
And of course, you can't appeal a consent order. You might say that there's some relationship there between the two because you're agreeing to sign up to arbitration. There's a contractual agreement there. In a similar way with a consent order, you're agreeing to something. I know they're different, but you could see there being a relationship between the two.
Well, as Claire Ambrose said in one, probably both of her reported decisions, one of the things you're agreeing to is to be bound by the result. But you're also getting a much more flexible process. You're getting the judge of your choice. So you're far less likely to want to appeal. But as I say, I think it proceeds on the assumption, or a misassumption, that appealing from His Honour Judge O'Dwyer is somehow easy. There's still quite a high bar there.
Yeah. And a very practical question raised about scanning in bundles and sorting them out in this remote working where people are in their own rooms, as it were, trying to run their offices. That's actually quite hard, to be fair, isn't it?
I don't know if you shouldn't be looking at me because I haven't worked with paper for ages. There can't be many documents in April 2021, April 2020, forgive me, that you need to scan if you think about it ahead of time. Everyone can download their bank statements.
Yeah.
Everybody can download their credit card statements, their share portfolio valuations can all be downloaded. You shouldn't need, in many cases, to be starting with paper. And so scanning ought now to be at a minimum anyway.
Yeah.
I can't magic a scanner into every solicitor's front room, but
if you've got one of these,
around it.
If you've got an iPhone, then you have got a scanner in your front room. There's a number of apps. I'm not paid by any of them to recommend them. But there are all sorts of scanning apps that, if, goodness gracious, you brought home papers with you when you exited your office's stage left, there are apps that will turn photographs taken from your iPhone into very good quality PDFs. And then once they're onto your system, I mean, I think it's going to be this transition phase where we've still got legacy papers. But I suppose, as the advocate who gets given, as Nigel was saying, these bundles of sort of strange PDFs, a plea for us all to agree a protocol for how these documents are being collated and sent across. I spend inordinate amounts of time converting my documents into searchable documents and then sending them back to the solicitors who sent them to me in the first place. It is going to be a tiring period as we translate into e-bundles, but those of us who are working from a series of iPads certainly are much less concerned about losing an iPad because I can remote wipe it. It's expensive, but it's less expensive than an investigation from the Information Commission officer as to where the bundle's gone.
I think Marina, it's either the remote family court version 3 document, that of Mr. Justice MacDonald, or one of the other guidance that's come out from either the family court or the civil court, does have a very good section on what software to use, how the section paginated, how new pages should be interleaved between the original download so it's searchable, etc. So I can see as slowly but surely all migrating to that, format. So there's a common format adopted by all of us.
And I've now
also.
Oh, carry on.
I was just going to say, in the way when we used to have very large court bundles and solicitors used to send a master copy to an outside agency to be photocopied, I'm sure it won't be long before you can easily find an outside agency that will receive all your PDFs and send back to you a court approved electronic bundle. I'm sure these sort of organizations are going to set up soon in the way they used to when it came to photocopying. So I would look for outside agencies perhaps for the smaller firms that solicitors. Most of the larger firms have in-house collation departments.
Well, hopefully, I think that this virus is helping particularly solicitors to understand the importance to moving towards paperless offices. If you're already operating a paperless office, we don't have any hard copies of documents, and we bundle everything very easily without any difficulty at all, with hyperlinks and hyperlinked indexes, and that's something that really legal practices should be moving towards anyway. And I think this virus has proven how important that is. And it's those practices that haven't gone digital, that are still very, very reliant on paper, that are probably struggling the most at the moment.
I've just got a final question, and that question is for the divorce surgery. Could either Sam or Harry explain whether or not the clients would normally be with solicitors first, and solicitors effectively act as the gatekeeper? How do they normally get their clients to them? I've been asked to check with you. Oh.
Well, in a variety of different ways. I mean, absolutely via solicitors. We've had lots of referrals from solicitor colleagues. We've had quite a lot of people who just, who've, I think the phrase is organic web traffic, but I'm not confident about that. Forgive me if that's wrong. And a few from mediators also. So it's quite a broad base, really. Thanks very much, Harry. And just now, to draw this to a close, to thank everybody who's participated in this for being on this initial virtual conference. I think it's certainly a first for me. I don't know if it is a first for anybody else. But just to say thanks to everybody for giving up their time. Thank you also to all of the people who've been listening. I hope you found it useful. I hope it's given you some new ideas, new projects to think about, and also new ways of working in what we now call the new normal, I think it is. Is it time for lunch now? Question mark.
Yes.
Yes.
Definitely.
I'm going to release all the ravenous presenters to go to their individual kitchens and make their virtual lunches, but lovely to see you all, and great to be connected in this way. Thank you very much, everybody.
Bye-bye.
Thank you, Suzanne. Goodbye.
Bye.
Thank you.
Cheerio.
Bye-bye.